HCA 322, Week 2, Discussion 2, Courtroom Drama. Good evening. My name is Jane Doe, and I am the administrator for AU Hospital, which is a public hospital. I am here today in response to allegations that our organization disregarded HIPAA privacy rules for information sought for administrative or judicial proceedings. We at AU Hospital are aware that the patient is the legal owner of their protected health information, or what is called health records, and therefore has the right to decide who will have access to them. The rights of a patient's health records is covered under HIPAA law under the privacy rule. The patient must authorize all disclosure of their protected health information and any identifiable health concerns. The rights of the patient include being able to receive copies of their health records, which we do provide when it is requested. The records are transmitted electronically for the patient for a small fee. The patient's request is mandated through the HITECH Act, which is part of the American Recovery and Reinvestment Act of 2009. The information that AU keeps in its database is coded, and only authorized personnel has access, such as doctors, nurses, labs, and specialists, and they are used to plan and implement the patient's health care. They can participate in research or as a means of billing the patient. These rights were given in a pamphlet to each AU patient as part of their welcome packet, which includes how their PHI is used and with whom it will be shared, which can also be sent via email for one if one is available. It is discussed and signed electronically by the patient. If it is requested, the patient can receive a record of who has received a copy of their PHI, the date, and the reason. AU takes PHI security very seriously, and we see any breach in that security as an egregious attack on AU Hospital as a whole. I am here to contend that PHI records were not sent impermissibly, nor disclosed the protected health information of one of his patients, Ms. Joan Doe, in any matter that would be inconsistent with the HIPAA laws. AU did not impermissibly disclose the protected health information of his patient, Jennifer, nor were we contrary to the privacy rule protections for information sought for administrative or judicial proceedings. The hospital did not fail to determine the reasonable efforts had been made to ensure that the individual whose PHI was sought, in this case, Jennifer Doe, and she would have received a notice of request or failed to receive notice through her own neglect. We are confident through documentation that satisfactory assurance that the party seeking the information made reasonable efforts to secure a qualified protective order. The right to information that healthcare facilities disclose includes law enforcement agencies and is considered non-routine, which is not routine for AU Hospital. Any request of this nature has a specific chain of command that is followed, and upon investigation of this request, they were followed. There were several attempts to contact the patient with no response. Each request is documented and is available as evidence as part of this court's proceedings. According to PHI specialists on record, the PHI of Jennifer Doe was disclosed only after many attempts were made in accordance with HIPAA, and only then was the protected health information disclosed as requested by the subpoena. Further, to respond to administrative requests such as administrative subpoena or investigative demand or other written requests from a law enforcement agency, because the request is made without judicial involvement, the rule requires all administration requests to include or be accompanied by a written statement that the information request is relevant, material, specific, and limited in scope, and de-identified information cannot be used, which is what AU did because of the plaintiff's neglect of responding. We only gave the information that was requested by the law enforcement agency and nothing more. The plaintiff was not harmed in any way. We acted in accordance to the HIPAA laws and law enforcement. According to the Privacy Act of 1974, there is a need to balance the potential harm to plaintiffs from the disclosure of protected health information because of the needs of the requesting party for the particular information. See Perry versus State Farm Fire and Casualty 734F.2D1441, 1447, the 11th Circuit, 1984, which is what AU Hospital did as a matter of cooperation with the law enforcement ordered subpoena for the PHI of the plaintiff, Ms. Jennifer Doe, after exhaustive steps were taken to secure her permission for such release of her records. Thank you very much and have a good evening.